Question is for the Attorney-General. One way victims can be controlled within a family violence relationship is if an offender monitors their movements through the use of GPS technology. A recent study by Westnet, a peak national domestic violence body, revealed that there was a 245% jump in victim survivors being tracked by GPS apps and devices last year. There are offences in the Surveillance Devices Act relating to this behaviour, including Section 7, which is the regulation of installation, use and maintenance of optical surveillance devices. Sentencing Advisory Council data tells us that out of the 45 offenders charged with this offence between 2016 and 2019, only 6 received jail time. Further alarming is a lack of data, i.e. there is none, for Section 8, through which is the regulation of installation, use and maintenance of tracking devices. Attorney, can you tell me how many people have been charged with the Section 8 offence since 2016 and what the sentencing outcome of offenders has been?
Attorney-General.
Thank you, President. I thank Mr Grimley for his question. It's a really important issue. Obviously, the use of surveillance devices or GPS as a way to effectively stalk, harass or keep tabs on someone is abhorrent, and because it's so covert, particularly disturbing for victims because they either don't know what's happening or they're unsure whether they've taken measures to be able to stop it. As you've identified, there are offences under the Surveillance Devices Act. It's also relevant in relation to family violence safety notices, and using coercive devices can form part of a breach for personal safety and family violence intervention orders. For instance, in relation to the specific information that you have sought, as you've identified, the Sentencing Advisory Council is looking at offences under the Surveillance Devices Act, and that will be fed into the VLRC, a lot of acronyms in my portfolio, into the Victorian Law Reform Commission's review into stalking. And it's part of the current public consultation process. And I've got to say, having just released tabled the last Victorian Law Reform Commission's report into sexual offending, the work is fantastic, and I really look forward to the stalking report and the recommendations and the findings of that report. I know it's of immense interest to the Hinch party, so these are issues that we can continue to talk about, and I do thank the VLRC for accepting that reference and that important work, taking into account the Sentencing Advisory Council's work at, as you've identified, perhaps the appropriateness of the offences, how many people are being charged, and indeed how many people are actually receiving appropriate sentences for this inappropriate behaviour.
Mr Grimley on a supplementary.
Yeah, thanks, President. Thanks, Attorney, for that answer and feedback. Jess Hill's See What You Made Me Do book and SBS docu-series demonstrated that coercive control can be exhibited through electronic tracking of a partner's car, wallet, phone and even through a child's teddy bear. In a piece by the Herald Sun recently, private investigator Paul Walsh of Asia Pacific Security Group said he had never had more work on surveillance-related family cases. It seems that there should be, at the very least, a mandate for record keeping of these devices being sold for cars, which could be used as evidence in court to demonstrate controlling behaviour. Attorney, given the risk present in this increasingly worrying trend of perpetrators utilising GPS technology to track their partners, how does your department intend on addressing this in order to maintain the safety of family violence victim survivors? And I do realise that you probably covered off some of that in your previous answer.
Thanks, President. I thank Mr Grimley for his question. It's terrifying, the lengths that some people will go to exert control over someone, very generally their partner or former partner, and as you've identified can be particularly common in family violence situations, and as I've identified it does form part of the family violence legislative response in relation to being able to obtain safety protection notices, and also if evidence of any of that type of behaviour can amount to a breach as opposed to a physical breach, for instance. I'm very keen in this area. I acknowledge that we've been talking about technology and surveillance and their impact on the criminal justice system for some time, but I think it'll be really useful conversation that will be generated from the consultations with the VLRC report and the findings, because it's very much connected to stalking behaviour.
Mr Davis.
President, my question is to the Attorney-General.